Hold on. Okay, so get here. So good morning to everyone, or afternoon or evening to everyone who is watching this event. My name is Lucas Rutes Gonçalves, and I'm here to present panel number 7.1 about intellectual property laws and artworks generated by artificial intelligence. Today's panel is going to be held in English by the three speakers which I would like to welcome to the event: Professor Ryan Abbott, Professor Rita Matulianite, and Professor Andres Guadamus. On behalf of GEDI and the event's organization, I'd like to say that it is a great honor to have you three in our event debating such an important topic. Also, I would like to present how this specific panel is going to work. It starts now at 10 o'clock Brazilian time and should be ending around midday. Each speaker has up to 30 minutes to make their presentation. After that, the remaining time of the panel is going to be devoted to debates and questions from the audience. Since the event is being broadcasted on YouTube, we would ask each one of you who has a question to write it down at the comment section so that I can read them to today's speakers. Also, if possible, please do write the questions in English to make our lives easier. And now, to begin his presentation, I would like to call Ryan Abbott, who is a professor of law and health sciences at the University of Surrey School of Law, adjunct assistant professor of medicine at the David Geffen School of Medicine at the University of California, a partner at Brown, Naismith & Kahn, and a mediator and arbitrator at JAMS, Inc. Professor Ryan, the floor, or better, the stream is yours.
Well, thank you. It's a great honor to be here today. It's unfortunate we can't all be together in person, but I'm sure the Zoom will still be a lot of fun. Interestingly, I noticed that artificial intelligence and copyright is really the topic of the hour, and I see we have already had several panels on this. Hopefully this will give you a somewhat different perspective. I believe Professor Sergio Branco has provided some grounds for not protecting these sorts of works, and I'm going to provide a different view of the subject. One reason why this topic may suddenly be of interest, although people have been claiming that AI has been making works that would otherwise be eligible for copyright for decades. You know, the US Registrar of the Copyright Office considered the question formally in the 1960s. There's some evidence that even back in the 1950s, the Copyright Office had rejected such applications. So this is not a new phenomenon. But what might be a new phenomenon is the fact that AI has been doing some of this stuff for a long time, but in almost an academic sort of way. And now it's starting to do some of the same things, but in more commercially relevant sort of ways. So just to give a greatest recent hits list, this is a picture of a music app playing called Endel, which you can stream on Spotify. And Endel makes bespoke music just for you, based on things like your heart rate and other various factors. It makes music in real time. So this is not music that a person has composed in advance. It is music that an AI programmed by people is making in real time. Warner Brothers attracted some attention last year by reportedly signing the app for 20 records. They didn't actually sign the app. They signed a distribution deal with the company that manages the app. And to deal with some of the copyright issues, or because they thought it was most accurate, they listed some of the programmers as the authors of the work. Although the lead programmer said essentially all of these songs came out of the algorithm they had performed with a push of a button. AI is not just making interesting songs, it's also making movies. I was actually going to show some video clips that AI had made from DeepMind last year, but I thought that it might not work over Zoom. So instead I'm showing this picture of a screenplay written by an AI, a neural network trained on existing sci-fi screenplays, that was brought to life by some prominent actors in 2016. It's called Sunspring. It's mildly entertaining for an AI piece of work. It is on YouTube. You should go check it out. Songs, videos, articles, paintings. This, of course, in 2015 was the portrait of Edmund Bellamy. It went on sale at Christie's and sold for almost $500,000. Again, a painting, quote unquote, made by neural networks. It does seem to be missing a nose. I'm not sure whether I could have painted something like this, but that's something I think about half of the art that sells in modern art galleries, and no one's paying me $500,000 for my art. So not only has AI made a painting, but it's made a painting that was commercially valuable, and it is making a painting that Christie heralded as the introduction of, a substantial market for AI work. So for lawyers, this sort of thing raises a bunch of interesting questions related to copyright. Firstly, because copyright is associated with having an author, and in some jurisdictions depends on having a human author, there's a question about whether or not this sort of work could get copyright protection at all, which is obviously a fairly important commercial question, although there might be other grounds on which there could be some protections. If you didn't have copyright protection for that portrait, anyone could copy it and use it in a PowerPoint deck in Brazil when they're talking about copyright. Anyone could play that, Sunspring movie whenever they like. Anyone could use Endel's music without accounting to the creators of that. Maybe that's good, maybe that's not good. Aside from the subsistence of copyright, we might ask, well, who is the author on, let's call it an AI-generated work? And there are a lot of potential ways to think or talk about this, but I'll refer to it here largely as something that doesn't have a traditional human author. Of course, there are ways of thinking about people as non-traditional authors, either from programming or using or owning the AI doing this, but no one who would traditionally qualify as their own on an author. And then there are issues of ownership. So, who or what would be the author on something, who or what would own something like this. These are questions that have occupied legal academics like Andres and Rita for a very long time, but only recently have really seemed to gain in commercial relevance to the point where people are really interested in answers to these questions. Last year, the US Intellectual Property Office launched a request for consultation on AI and largely patent rights, but then a second one on AI and other sorts of intellectual property like copyrights. So the US PTO reported that it is really considering these questions and others related to it holistically and looking to form new views. The World Intellectual Property Organization has now had its third conversation on AI and IP. They have a draft issues paper published, and they are looking for harmonization of some of these because there is really a critical geopolitical element to this and an international trade element to this, because you may have, for example, copyright for an AI-generated work protected in one jurisdiction but not another. And most recently, the UK Intellectual Property Office has issued a call for consultations on this. That consultation closes by the end of the month, so maybe some of you will be inspired by some of the panels that you heard during this conference and will submit comments to it. The earlier consultations received quite a few comments from national offices, from intellectual property organizations, from individuals and academics and so forth. Now, there is some law on this, much more than there is, say, on the patent front, but the UK was the first country in 1988 to explicitly provide statutory protection for what everyone likes to call an AI-generated work these days, which I briefly tried to call in a piece of scholarship a computational piece of work, and no one liked that, and which the UK calls a computer-generated work. And it defines it in the Copyright Designs and Patents Act under Section 9.3 as a work created by a computer lacking a traditional author. And in such a situation, the producer of the work is deemed to be the author. So that is a person like a film producer who makes arrangements necessary for the work to be undertaken. And there's only been one case one court case involving a computer-generated work, and that was Nova Productions v. Mizuma Games. This was in 2006, decided by Justice Kitchen. And in that case, you had competing manufacturers of billiard games, and there was an argument of copyright infringement. But in that case, no one was debating subsistence of copyright in the underlying work. the justice held that there was no copyright infringement because, the games were essentially very similar, but there are only so many ways you could program a game of pool. And it really didn't get into the computer generated work issue. The justice did hold that to the extent this would have been an issue, the person on the plaintiff or claimant side who was designing the game would have been held to be the author, because he was the person, even though he wasn't generating individual frames, who had, put in the design input into the programming and thus could be deemed the author, not the player whose individual actions did generate the ultimate graphics, but who wasn't exerting any sort of artistic impact on this game. The US, on the other hand, since the 1970s, has less formally had a human authorship policy. And so the Copyright Office will reject something for which a human author is not identified. There is no statute in the United States, and for a long time this wasn't even based on an official policy. But now the Copyright Office cites the 1886 case of Burrough-Giles v. Cerrone in support of preventing non-human authorship. And that was a case involving a famous picture of Oscar Wilde here, which Napoleon Cerrone went to great efforts to stage. The Burrough-Giles lithographic company started using it without his permission. He sued for infringement, and the Burrough-Giles lithographic company argued in response, you can't have copyright in a photograph. It's just a mechanical reproduction of a natural phenomenon. Well, the court held that really any intellectual creativity which is given shape through the mind of an author is eligible to copyright protection. And this was a Supreme Court case, really, along with the trademark cases, that held these sorts of expressions were eligible for protection. It was the first case holding a photograph was eligible for protection like this. The law has changed now. Very little effort is required to have copyright subsist in something. But the Copyright Office is interpreting this to think that machines don't have minds, can't give things creative expression, and for that matter, neither can monkeys. So this was a case around 2011, I believe, where a nature photographer, David Slater, was in Indonesia, and a crested macaque named Naruto picked up his camera and took its own photo. This is, by the way, not a happy monkey. This is a display of aggression among macaques. So this is Naruto looking at his image, deciding he doesn't like the monkey on the other side of it, and he is going to intimidate him. The monkey is not terribly sophisticated, but it did snap a pretty good selfie, and a selfie that David Slater found to have some commercial value. Initially, he reported that he had just left the cameras around and Naruto took his own picture. And then after reflecting on it a bit, realized that he had in fact carefully staged this, studied the monkeys, and enticed the monkey to come and take its own photograph. But in any case, he started selling pictures of the monkeys. Other parties started using the pictures of the monkeys without his permission. He threatened them with copyright infringement, and this generated enough attention that the Copyright Office in 2014 formally came out with its human authorship requirement, and still lists to this day photographs taken by monkeys are not eligible for copyright protection. That seemed to put an end to the issue, but then PETA, People for the Ethical Treatment of Animals, sued David Slater in California in the Ninth Circuit in federal court, alleging that Naruto was the owner of the copyright in the photograph. They were bringing this suit as essentially a friend of Naruto and would administer the proceeds on his behalf. And that case got dismissed on appeal. It actually didn't get dismissed because of any challenges related to the human authorship policy, but because the Court of Appeals held that animals don't have standing to sue for copyright infringement. The court said if an animal is going to have standing to bring copyright infringement, Congress needs to plainly state so. That does not occur in the Copyright Act, and absent something extraordinary, monkeys can't bring lawsuits. So the case went away. The policy issue didn't so much, and here we are today. You know, this is an issue that is playing out in many jurisdictions. The UK's policy is only around in about a handful of former Commonwealth countries like India, but there were two cases in the past couple of years in China over alleged AI-generated works, one of which was held not eligible for protection, one of which was. You know, in the case where it was, the company, you know, this was a 10-cent AI called Dreamwriter, The company was deemed the legal author of this. They have something like the US's corporate author or work for hire doctrine, where a company can be an author. Although in that particular case, the judge held that the human team behind the AI essentially had assigned any rights to the company. And so the work was protectable, even though Tencent said this was made by an AI. And we're waiting to see how other jurisdictions develop something like this. Not to veer out of copyright too much, but I've been leading a team that's been applying for patents on two AI-generated inventions. The judge held that the human team behind the AI affecting multiple areas of intellectual property law. There's a lot less law on the patent front than the copyright front. We've so far submitted these applications in around a dozen jurisdictions. We've been rejected in the US, the UK, Europe, and Germany. All of those are under appeal, and we are waiting to see how the law develops. But how should the law protect something like this? Well, there's two sorts of ways of looking at it, I think. One is, well, what does the current law hold? And there is a way to shoehorn this into current law. And, a better question might be to ask, well, what is it that we want out of copyright law? And what sort of laws would help us best achieve this? And we want a few things out of copyright law. And different jurisdictions have different senses of what they want out of copyright law. So in continental Europe, for example, they are fixated a bit more on the moral rights of human authors and on protecting the rights of authors. In the Anglo-Saxon tradition in the US and the UK, there's much more of an economic incentive argument behind copyright. This unusually even appears in the United States Constitution, that the reason that we have things like patents and copyrights are as an economic incentive to inventors and authors to invent and author corporate, creative works. Well, some academics have said you'd be crazy to want to grant a copyright for an AI-generated work or a copyright to an AI because an AI really could care less about making money or having a copyright or being an author. And clearly that's all true, but it also looks at the issue the wrong way. It's not the AI that cares about copyright. It is the people making, using, and owning the AI that care about copyright. It is Tencent that cares if we use an AI to generate an article, can that get the same sort of protection as a person who generates an article? And if what we want is the generation of creative output, then the best way to do that, to the extent that we think the copyright system is the right way to do that, is by providing similar sorts of protections for AI behavior and human behavior. So it is not that the AI would have a copyright, but it is that we would be encouraging companies like Google and Tencent to be building AI that can generate creative works, and society would be the ultimate beneficiary of more memes about the election generated by AI. To the extent those memes are better than human generated AI, investment will flow back to the companies building these. You will have improved development of AI that can make useful things. We will have better terrible sci-fi movies on YouTube. We will have better bespoke music. The arguments for incentivizing this are really not so different than the arguments for incentivizing human activity, only one step removed. And of course, as a matter of fact, though, there is a romantic conception that the person benefiting from copyright is someone working tirelessly at night, over a oil-lit candle writing a manuscript. In point of fact, for the most part, beneficiaries of this already are corporations that hire authors or distribute works, and J.K. Rowling is really the exception to this. And if you were to protect this sort of thing, who or what would be the author? And in the patent applications that we filed, we listed the artificial intelligence as the inventor of those. And I similarly think that the artificial intelligence should be listed as the author of an AI-generated work. And that is not a matter of giving a right to a machine or giving credit or acknowledgement to a machine. It is to do two things. It is, one, to inform the public of how a creative work was generated so that the public knows this is something made by AI. And it is designed to keep someone from taking credit for work they haven't done. So if we have an AI that can make 20 albums at the push of a button, which we now have, right? I shouldn't be allowed to be an author on those 20 albums because I pushed the button. That would equate my work with the creative genius of someone like Katy Perry, and it would really devalue what it means to be a human author. So for those two reasons, I think that listing the AI as the author is the appropriate thing to do. Of course, that is not to say that an AI would own a copyright. an AI could not legally own a copyright because it doesn't have legal personality. But even if we were to grant it legal personality, it wouldn't care about getting a copyright. It wouldn't be able to enforce a copyright. It just wouldn't make a lot of sense. So I would propose, much the way that an employer owns in the US and the UK copyright generated by an employee, that the owner of the AI would own its copyright, and there would never need to be a transfer of the copyright. The copyright would just vest initially in the AI's owner. There are some objections to doing this sort of thing. One of them is historical. Copyright for at least several hundred years has been closely bound to the idea of a human author, right? You see ideas like that reflected even in the 18th century in the Statute of Anne, or in the 19th century in the Berne Convention. But even without a whole lot of historical research, it should occur to you that the authors of the Berne Convention were not thinking about AI-generated works. And so, yes, it is true that human authors, at least under most systems, are morally deserving of some rights associated with that, and those rights differ based on where someone is an author. But that really doesn't apply in the case of an AI-generated work, because an AI doesn't have rights, and an AI doesn't care if you take its copyright, and an AI doesn't care if you unplug it and toss it off your balcony. To the extent that we assume an author has to be a human being, that is just an assumption that has been baked into the law and shouldn't dictate how we're solving the problem now. And to the extent that was really a deliberate choice, it was a deliberate choice being done to protect human authors from corporations, and saying, well, okay, even if a corporation owns your patents or your copyrights, we're still going to at least list you here so that you have acknowledgement for what you've done. And we will give you, maybe also, depending on the jurisdiction, a few kind of less important rights associated with that. And that's all well and good. Not saying authors don't deserve that sort of protection, but again, that really doesn't apply to an AI, which has no interest in being protected from a corporation. There are a couple ways in which, computer generated and human generated activity isn't exactly the same. So AI is hypothetically immortal. I mean, it really never dies, but then it never lives. So to the extent you have a term based on an author's life, that seems to present a bit of a problem. The UK has solved this simply by saying 50 years from the date it was produced. And frankly, we might think that 70 years plus the life of an author is a little bit too long anyway, so maybe that makes pretty reasonable sense. Or in the US, we have a term of a longer term for where a corporation is deemed an author on a work for hire, and that's based from when the work was first published or produced. So there's simple solutions to the term problem. And then some jurisdictions do have authors' rights or moral rights that can be waived maybe sometimes, but can't be assigned or transferred to an employer. And the UK has handled this by simply saying those don't apply in the case of an AI, right? Or you could have those rights belonging to a corporation in the case of an AI, but it's certainly not an insurmountable problem. Probably the most significant challenge to this that people bring up is really the concept that an AI cannot be creative. I mean, sure, it can make something that looks creative. So, you saw it's making music, you saw it's making TV screenplays, you saw it's making paintings, and one could argue they're still not that good. But something doesn't really have to be that good to get copyright protection. I mean, the notes that I scribbled about this lecture have copyright protection, and not only can no one read them but me, they're just not that good, period. But we don't get into the aesthetic merit of something. I mean, what's very clear is that if a person had made any of that music or the films or the books, it would be getting protection. And saying really in this case that an AI can't create is a lot like saying an AI can't think, which strangely enough is something computer scientists have been talking about for 70 or so years. It's something Alan Turing addressed in the 1940s, and I think he did it fairly persuasively. He basically said, well, this is not an interesting or relevant question, because what does it mean? And I think that argument is valid here in two senses. I mean, one, what does it mean to be creative? We know what we're talking about when we say, I'm creative, I'm writing notes, I'm drawing a painting, but we don't really know what's going on. We're either talking about it functionally, like, yes, you're a person, you get some input, a piece of paper and a pen, and on the output side comes something that's eligible on its face for copyright protection, some terrible doodles, right? A machine can think like that, and there's no question about it. If you mean, can a machine think exactly like a person? The answer is clearly no. But it's not exactly clear how a person thinks. And it's not clear in what meaningful sense a person thinking and a machine thinking are different. A machine may lack semantic understanding of the things that it does, but I don't need to have semantic understanding of the photographs that I take with my iPhone. They're just eligible for protection for the time that I take a picture. And that's very much the case of what you want out of copyright law is a regime that generates more creative work and functionally protects them. So I think the answer to can a machine think is, well, it depends what you mean by think. And more importantly, it really doesn't matter. There's another argument against this, which is, okay, so machines have been making creative works for a long time and they've been really bad. And now they're getting to the point where they're not so terrible anymore. And for simple things, people can no longer tell the difference between something made by an AI and something made by a person. But if you look 20 years into the future, AI may get really very good at some of this stuff. AI could conceivably generate every possible song, that a human being could listen to, and rank order those according to your preference and provide you a playlist for the rest of your life of music you're likely to listen to. And if it did that, it might prevent people from being creative and generating their own music. If an AI generated all possible music, which, by the way, statistically speaking, is really hard, but hypothetically anyway, if it did that, you'd have a really hard time having people be creative. Well, I think that wouldn't be a bad outcome. Because if, again, what we want out of a copyright system is to generate creative works, I think it would be a great outcome to have every possible song ever written that the world could enjoy now. And people will do one of two things. They will shift to new industries. So 40% of people in America in the 19th century used to be in agriculture. Now it's just 3% due to technology. But agriculture is more productive than ever, and people have found new things to do. So if AI makes every possible song, more people will move into other forms of being creative. And if we ever really move into a world where AI can do every creative thing better than a person, people can still be creative. It just won't be commercially necessary. They will do it because they enjoy it. The same way that I play chess because I enjoy it and not because I can beat a computer. I will never beat a computer at chess, or at least one of the better ones. But that doesn't mean I still can't play chess. That doesn't mean I can't jog places, even though I realize driving there would be a whole lot faster. There are reasons people could do things for their own personal satisfaction and development. And in a world where AI has made every creative thing imaginable, we are no longer going to have need for human economically productive activity. There will be essentially an unlimited amount of wealth. I don't want to pitch my own book at the ending of this, but this slide accidentally found its way into the slides, and Lucas insisted that I talk about my own book a little bit. So I will just mention that a few months ago, I had a book come out on this subject. And more generally, I think what we're witnessing now with AI is AI stepping into the shoes of people in a much more prevalent sort of way. And we see that the law treats human activity and AI activity very differently, even when they still have the same functional outcomes. And this is something that applies in tax law, in tort law, with copyright, with patents, with criminal law. And the book talks about how the law distinguishes between these two activities, and often in harmful sort of ways. So if what we want is more creative work, we really shouldn't be distinguishing between these sorts of activities. We should be encouraging both. And in the near future, we're going to have a largely a mix of human and AI activity. But when you get to the point when an AI can do something better, safer, cheaper, and faster than a person, that's the sort of thing that we as a society should encourage. There's going to be plenty left for people to do with net benefits all around. And if we ever get to a point where there's really nothing a person can do that an AI can't, that's going to be the least of our problems. And I'll end on that. Thank you.
Thank you for your presentation, Professor Ryan. It was really a great summary of the main discussions about this topic. And immediately, I'd like to continue the panel. I would like to call Rita Matuglioniti, who is an international expert in intellectual property and information technology law. She acquired her PhD degree from Albert Ludwig University of Freiburg, Max Planck Institute for Intellectual Property and Competition Law in Germany in 2010. Since then, she researched and lectured in universities in Japan, Germany, Lithuania, and the University of Newcastle in Australia. Professor Rita, if you please.
Thank you very much. Let me just share my screen. Okay, so hello everyone. Good morning, I suppose, to Brazil, and good afternoon to panelists in the UK. And for me, it's probably good night. It's 12:30 a.m. at night. So if I have difficulties in articulating myself, you know that my coffee is not working. I really enjoyed the presentation of Ryan. Thanks a lot. And I suppose everyone already knows that there are a number of different issues related to AI and copyright. One of them is whether AI-generated works should be protected and who should own copyright. That Ryan so greatly covered. But I'm going to focus on a different issue, that is machine learning and copyright infringement. And I give additional title or a different title to my presentation is Copyright Should Not Impede AI Innovation. And so it is an issue. The question there is essentially, when we feed copyrighted protected content in AI algorithms, is there a copyright infringement, and should there be one? As we maybe some of us already know, there is no infringement in such cases in the United States because of fair use provision. Also, it is not an infringement to feed copyrighted content and machine learning modules in the EU due to recently introduced data and text and data mining exception. But in most other countries around the world, including Australia, and I believe in many countries in South America, the situation is not yet settled, which means that there is essentially every time, apologies, every time AI developers use copyrighted content to train their AI modules, they actually infringing or might be infringing copyright. So in my presentation, what I want to do is I want to look at kind of explain how this machine learning and copyrighted content interrelate, how it all works, whether it is legal actually to feed copyrighted content in machine learning module, should it be legal, and if so, what sort of exceptions would be most suitable. I will base my presentation on Australian law. However, I think the discussion will be relevant to many other countries that actually haven't sorted out this issue yet, and that I would suggest should do it as soon as possible. Okay, so machine learning and copyright, how it works. So I'd like to give a few examples to illustrate that. So we probably have heard that there are a number of AI technologies that already facilitate tackling this international medical emergency caused by COVID-19. So some of these machine learning modules were trained by copying and reproducing and feeding large amounts of scientific articles into the algorithms. As we know, scientific articles, of course, protected by copyright, and they've been reproduced and compiled into data sets before they've been fed into the algorithm. So do we have infringement there, or do we need permission from the right holders of those articles? Another example is Google's Assistant program. So Google took a data set consisting of thousands of romance novels. One of them is, for instance, a novel by Erin McCarthy. Nice picture. And Google fed those thousands of copyrighted novels into the machine learning module in order to make their Google Assistant more conversational. So they kind of use more richer vocabulary and can interact people in a more lively way. Google, of course, did not ask permission from authors who wrote those books, neither from their publishers. And those novels were taken essentially from online platform Smashwords, where they were published. Now, the third example is, where's my third example? It disappeared. I wanted also to make one more example, which was about Clearview. Not sure what happened with my slides. So Clearview, anyone might have heard about this company that developed face recognition technology by scraping thousands and thousands of photos from Facebook and other many websites without, of course, authorization. And it was kind of caused a lot of questions about privacy, but there is also a copyright issue there. Photos are protected by copyright. Can you just copy them and feed into your algorithm to create a face recognition technology? And a final example that I wanted to give was, and I'll discuss it later, that's why I want to mention it, is the next Rembrandt project. Again, I don't know where it disappeared from my slides, but apparently the Dutch company, they took Rembrandt's paintings and copied them and fed them into algorithm to create a machine learning system that can produce paintings very like using a style that is very similar to Rembrandt. So essentially, when you see that picture, which is unfortunately on the screen now, you could really think that this is Rembrandt's work. So, so now, is this legal? And as already mentioned, in the US, such sort of activities, that is feeding copyright protected works, be it literary works, photos, or musical pieces, would generally look like be legal in most cases and would be covered under fair use. So Google Books case that I'm sure all of you know about, essentially the court found that when Google digitized thousands of books, created this searchable engine and allowed kind of text and data mining as well as display of snippets, is covered by fair use because essentially it's transformative. And such text and data mining activity is generally the predominant part of machine learning process, and that's why most machine learning projects would be covered by fair use in US. And in the US mentioned text and data mining exception was introduced in the recent Digital Single Market Copyright Digital Single Market Directive. And its main purpose actually was to enable AI development. AI industry was lobbying for it to be introduced because they believe that copyright currently creates an obstacle because of this legal uncertainty as whether feeding copyrighted content is legal or not. So unfortunately in Australia and as well as in many other countries, the question is yet not answered yet. Oh, so here's the next Rembrandt picture that I said. The slides got shifted somehow. And this is this clear view technology that I just was talking about. So, sorry, not sure what happened there, but a bit of a mess in my slides. So let's take a look at the question now, whether it is legal under Australian law. And I imagine similar answers, conclusions might be reached under other laws. So in Australia, as in many other countries, we have this exclusive right of reproduction, which is derived from, let's say, World Copyright Treaty and World Performance Phonographs Treaty as far as digital reproduction is concerned. And of course, this right covers any sort of digital reproductions, both permanent and temporary. So if we think about feeding content into machine learning like system, reproduction occurs multiple of times. In many cases, first you have to compile a data set where when you reproduce those works permanently, and probably you have to modify them to some extent. When you can also talk about moral rights infringement here, but I'll leave that issue from this presentation. And then when during the machine learning process, a number of temporary copies are being made as well. And as we know, a reproduction right is so broad to include all sort of copies, and that's why it's triggered. Then we have next question. So can we apply any of existing copyright exceptions in those jurisdictions where we do not have specific text and data mining exception or fair use exception like in Australia? So of course, there are many exceptions that we could consider, and I don't have really time to go through all of them, but to give a few examples, we have in Australia these temporary reproduction exceptions that are similar to the transient copying exception, for instance, Information Society Directive in the EU. However, if we look carefully into that exception, we will see a number of issues. So first, for instance, they allow normally only temporary copying, and as I already mentioned, when you create data sets of using copyrighted content, these data sets normally permanent, and actually they're very valuable. So creating data sets requires a lot of time, and you would want to keep them and probably even sell it to others for or kind of give it for free, so that they can train their AI modules based on those data sets. Now, another issue is that these exceptions refer to incidental copies, like incidental copies, and these data set, this content that's been taken and reproduced for machine learning purposes is not normally incidental. It's very carefully selected and even adjusted to meet the requirements for a particular module. And there are a number of other issues that result into the conclusion that temporary reproduction exceptions do not apply in machine learning scenario. Now, we would have to look also at fair dealing exceptions that exist in Australia. So they are different from, let's say, US fair use concept and similar to fair dealing exceptions that exist in the EU, in the UK, since they're limited to particular purposes like research and study, criticism and review, parody and satire, news reporting, and judicial proceedings. Now, again, I can't look at each of them, but I would like to give one example that kind of demonstrates problems, or some of the problems that we encounter when we try to apply any of these exceptions. So, for instance, there is this AI module we could call which is called Heliograph. It's used by Washington Post to produce press articles, and you see in 1 year it produced 850 articles. Now, such sort of modules are trained by feeding into them thousands of pieces of text. Now, let's assume that this heliograph was fed with articles or like pieces of text that was not licensed or was not owned by Washington Post themselves. And the question is, do we have an infringement, and can we rely on the fair dealing for news reporting purposes? And if we look at fair dealing exception, one of the issues that we have there is that fair dealing exception could be relied upon by Washington Post, because they would be using this, let's say, AI module for news reporting purposes, but normally Washington Post would not be the entity that develops such AI module, and it would be some external company that developed that module for profits to sell it. And for this reason, they would not satisfy news reporting purpose requirement, and they would not be able to rely on exception to kind of create such a module. So this is one of the issues that we encounter when applying different fair dealing provisions. They can be relied upon by, let's say, researchers, or by, if we look at the list, let's say persons who are doing criticism and review, but not by the AI companies that actually develop those AI modules. Okay, so there is, so we see already that we have here an infringement, and it's not, essentially it's very difficult in most, if not in all cases, to apply any copyright exceptions. Now, we have heard argument in the US and developed also during European discussion as well in Australia, that there shouldn't be infringement of reproduction right in the first place, because when we reproduce it for machine learning purposes, there is this such sort of reproduction is non-expressive. So we reproduce those works, but those copies are not being used to read the content, to enjoy, to get information from the content. It's being used to train a machine, and that's why it's non-expressive, and it shouldn't amount to reproduction in copyright law sense. Now, as European Union kind of pointed out, it's very unclear whether courts would accept such a interpretation of reproduction right, and that's why they said, well, we need to clarify that situation as soon as possible and introduce an exception. In Australia, at least, I would argue that it's very unlikely that the courts would accept this sort of interpretation, because they tend to read the exclusive rights broadly and interpret exceptions narrowly, and that's why I would imagine that they would reject such argument, and they will quite clearly establish literary infringement of exclusive right of reproduction in most cases. So what do we have in practice? So we have those AI companies that develop those different machine learning products, and they very often use copyrighted content that they, for instance, scrape from online websites. And so what do they do? So I think that I could notice two different approaches. So when you talk to AI sector, they simply think that they are not doing anything wrong. They think if they get access to the content, wherever is it in online or offline databases, they think they can use it for free. They don't think there is an infringement. They probably have never even thought about it. Or if they thought, many of them have heard about fair use and about the US counterpart working on, using that all content in their machine learning modules without any issue, and they think that it applies in Australia, and don't think they're doing anything wrong. Now, creative industries, I think, have a bit of different approach, because people dealing with music or arts, they are more careful, and because they don't want their own works to be used by others without authorization, they also think carefully before using others' works, in their own activities. So I've seen many situations where, let's say, musicians who wanted to develop an AI algorithm by, training them on pre-existing music, only used their own music, or music that was open source, because they thought there is an issue there of using content created by others. So in both cases, however, we can see that the current situation under copyright law inhibits innovation in the AI sector. So AI companies are facing that legal risk of being sued for copyright infringement, while creative industries are kind of limiting themselves in their activities by using only very limited amount of content to develop whatever innovative AI kind of related creative products. So one of the questions that we need to discuss before thinking, so do we need an exception, something similar in the US or EU, is, can we rely on licensing in such situations? Can those AI companies go and just simply, get licenses from right holders? That's what right holders are advocating. Publishers especially saying, look, we are already providing licenses to researchers to use the kind of research articles for text and data mining services, so we don't need any particular exception. And these licenses are normally for free in case you have a subscription to a particular database. So in some cases, individual licensing is possible. We can also think about, for instance, Facebook. Via their terms of use agreement, they get access to all the data, uploaded by their users, and they can use that data for their machine learning projects as long as it helps them to improve their service. However, in other cases, individual licensing, of course, becomes impossible. If an AI company that doesn't have pre-existing contracts with whatever content right holders want to use, let's say, thousands of pieces of text that they scraped from online environment, it is essentially impossible for them to reach out to all right holders and get licenses. Now, collective licensing has been proposed in Australia as an alternative solution, and in some cases, actually, it could work. When you think about this Google Assistant case that I just discussed before, Google could have reached the collecting society responsible for literary works and could have got a license to use those thousands of novels in the machine learning project. However, in other cases, there would be a problem because some types of works are not very well represented by collecting licensing societies, for instance, photographs. So photographers are well known not to be very well organized in collecting copyright management sector. Also, if you think about all the online content that has great potential for machine learning purposes, it's easy to access. There's a lot of content and you just scrape it and use it. Of course, all these people that contribute that content online, they do not belong to any collecting societies, so you could not reach them out. Well, we could think of all different other collecting licensing models that are like compulsory licensing or even extended collecting licensing that we have for some cases in Europe. However, in my paper on which this presentation is based, when I was writing and kind of trying to examine whether it's an option to consider, I found that, well, essentially it would intrude into exclusive rights too substantially, and I don't think it would be justified to apply extended collective licenses, licensing module for in kind of machine learning context. And one of the reasons, as I said, it's limiting exclusive rights to unreasonable for no particular kind of sufficient reason. On the other hand, it would put AI industry, let's say in Australia, if such module would be introduced in Australia, in very uncompetitive situation. And if comparing to AI industry, of course, in, let's say, US, Europe, Japan, and China, where no licenses and no payments are required to use copyrighted content in machine learning context. So then the next question would be, okay, so currently we have infringement. We don't have a viable licensing module. Should we make machine learning legal under copyright law or use of content in machine learning legal? And again, the answer is not as easy as it might seem. So when we think about using of scientific articles in machine learning programs, we would say, oh, that should be certainly fine, because there are already actually established practices where the scientists can use these articles in machine learning projects under free of charge licenses. Now, if we look at Google Assistant case, we might have some doubts. Google is using romance novels for free to create a product from which they're going to profit. Why not to share that profit with the right holders of books, being like authors in this case, because they were self-published? And on the other hand, well, we could still develop an argument saying, but Google is actually using it non-expressive and transformative way. So they're not creating any competitive product that competes with novels. Also, they're not using it in expressive way that it uses like a teaching material for technology and creates a product that has an additional benefit to the society, entirely new product, which kind of, we could say, an argument in favor of allowing such uses. But if we look at this new Rembrandt project, we kind of think that that's the answer is no. We shouldn't allow use of copyrighted content to train machine learning project that creates, afterwards generates paintings that compete with essentially the paintings that were fed already, or the paintings in the market of that particular right holder. Of course, Rembrandt, in case of Rembrandt, copyright is expired, but we could think of similar project that could be developed based on copyright protected works like Salvador Dali works. Why don't we produce a machine that creates paintings very similar to Salvador Dali paintings and sell it on the market? Shouldn't we share any revenues with Salvador Dali estate because we rely on the reputation that he developed? So how do we what sort of solution we find? And I'm aware that I'm running out of time. So I think both in the EU and US, the main argument that prevailed in that discussion whether it should be allowed was overall benefit. So artificial intelligence technologies are driving the so-called fourth revolution. and they have immense potential in the future. And for that reason, we kind of give them priority and allow use of content with the purpose to create new products into different markets. Now, creative industries are left behind, yes, to some extent. So the content that they provide to our industries is like a fuel. An AI algorithm is an engine. And in this case, fuel becomes for free. And creative industries lose the opportunity to commercialize their content, which is kind of a pity because they already often struggle financially, especially like in Australia. Now, at the same time, they still have this creates new opportunities for them. Mainly, they themselves might develop new experimental artistic projects by using content, any sort of content for free. And also, there are some copyright safeguards that would prevent actually from, let's say, using DALL-E's painting to create a machine learning module to generate DALL-E paintings that are very similar to Salvador Dali, because the output generated by such product might infringe the copyright because it would be substantially similar to the pre-existing works. Now, the last slide, just I would like to look at quickly, is so now if we agree that we need an exception, eventually, after all this long discussion, which one? So we already, I'll give a very quick overview of the existing options. So of course, we could look at fair use, but the countries that do not have fair use, I think creative industry strongly oppose it because they find it overbroad and very uncertain scope, which requires lots of court cases before at least certain clarity could be established. Of course, it is great because it's flexible and adaptable to technological environment, and we see that all these new tech companies in US relied a lot on it to develop their new kind of models. Well, European exception is good because it's kind of narrow in scope and much clearer. At the same time, it's not very flexible and non-adaptable, and it adds to a long list of the existing exceptions and makes the Copyright Act even more complicated. That's why in Australian number reports did not preferred fair use and not text and data mine exception. But as currently Australia is actually looking for a middle ground solution, and they're thinking of introducing something like fair dealing for technical use, which essentially would allow users for technical use if they meet, well, if they're fair, if looking at the 4 factors that are very similar to fair use factors. So it's a middle ground, which is more flexible, adaptable than TDM exception and has clearer scope than fair use. And of course, it is kind of an option to consider for countries that have this fair dealing tradition and might be not very kind of suitable for countries that do not have such a fair dealing tradition before. Okay, so I'll finish here my presentation with the conclusion that artificial intelligence, as we can see from the picture, is actually the driving force of the 4th industrial revolution, and it has a potential that steam, electricity, and computing, these new technologies kind of had when they were introduced. And well, copyright shouldn't be the law that impedes innovation in artificial intelligence. While we know a lot of risks related to artificial intelligence, they probably would be better dealt by other laws, and we need to remove the current barriers that copyright laws in many countries still have in the context of artificial intelligence by introducing exceptions that are both flexible and sufficiently clear and also follows the copyright tradition of the country. Thank you.
Thank you for your presentation.
Just wanted to share this last slide with my contact details and mention that the paper on which I base this presentation is available on SSRN. If you Google it, you will find it. It's currently under review, but still you can make use of it. Thanks.
Sure, we'll be sure to share it with everyone on the comment section of our YouTube. This article about the presentation, it was actually really, really amazing. So lastly, I would like to present Professor Andres Guadamos, who is a senior lecturer in intellectual property law at the University of Sussex and the editor-in-chief of the Journal of World Intellectual Property. His main research areas are on artificial intelligence and copyright, open licensing, cryptocurrencies, and smart contracts. He has acted as an international consultant for WIPO and has done activist work with Creative Commons. Also, he has an amazing blog called Tecnolama and was present with us here in Brazil in the last CODAIP. We are glad to have you back, Professor. How are you doing?
Fine, thanks. Can you hear me first?
Yes.
Okay, excellent. I just switched to a more professional microphone. Let's see. Share. That should work. All right. And hopefully this will work. Okay, excellent. Now you should be able to see my slides. Excellent. All right. Thank you first so much for your kind invitation again. It's a pleasure to be here. I wish I was in. I was with you in Curitiba, but it wasn't possible this year. I would like to start. I always start with an apology, and this year I would like to start with an apology. My voice may break. I've been affected with COVID for a long time. So that's first apology. And if I lose track of train of thought and everything, I think that my brain is not working 100% anymore. So let's hope that holds. And also a bit of an apology about what may appear a bit like an unimaginable title. Last year, when I presented in Curitiba, I had two presentations, one on infringement and one on ownership or authorship. And it was the name was this, which is the name of the paper that I wrote, published with IPQ. This has been the title of presentation for for the best part of 5 years or thereabouts. I did want to update a little bit the paper, not only because I presented a version of this last year, but also because quite a lot has changed and since the paper was first presented, and it is going to be published an update as a book chapter soon, an edited book. So I'm going to present a few of the updates there, but also most importantly, I wanted to have a little bit more of a broad look at this. So I'm very thankful for both Ryan and Rita. I think I'm probably going to repeat a little bit of what they said. I think that there is quite a lot of overlap, and I apologize for that in advance. But I'll try to give it a little bit of a different slant, because I think that we are talking about some interesting questions about how to proceed. The law is very unclear in many jurisdictions, but I think they are moving in certain direction. But I want to take a step back and start looking at sort of the wider issues. So one introductory thought as well, I always start this when talking about artificial intelligence, is that we have to be very clear that what passes for artificial intelligence, what most people think of artificial intelligence, tends to be actually a little bit not artificial intelligence as such. It tends to be mostly statistics, and a lot of times there is a lot of hype. So whenever you see something being touted as artificial intelligence, you have to ask yourself, what is being talked about here? Is it the statistics? Is it just sophisticated use of Excel sheets? Or is it just really what we could possibly understand as artificial intelligence? So that is the first warning. And I wanted to sort of start a bit with how I got here, how I started getting really interested in the subject. I've been fascinated with what can be called non-human copyright for some years. I'm not going to go into detail here. Ryan already talked about this in great terms. We started with a monkey. I wrote a paper on this. I became obsessed with a monkey, like most people, back in 2012. But I then started looking that there was a pattern emerging. More and more what you could call non-human copyright. This is Manny the cat. He has his own Instagram page or Instagram account, and he takes selfies with his friends. Spoiler alert, I don't think that Manny is actually taking the selfies. I know, shocking, right? But it's interesting that, there is a market for this. There is Curubanda, who is a painting jaguar in Costa Rica. And Curubanda, as you can see here, in the creative process of making some paintings, and even sheep that are now being deployed in Scotland, in places like the Isle of Skye, to actually take pictures of the different places in Scotland. I'm going to my next paper is going to be titled like this. I think, "Do Sheep Dream of Electric Copyright?" And even plants. This is a fabulous project where there is an art project where a cryptocurrency is tied to a mint plant. And this is by some artist in Amsterdam. And the cryptocurrency goes up and down depending on the health of the plant. Okay. So it's a growing number of things that are sort of, I should have mentioned also ghosts and aliens. There is some case law on, very interesting case law on that. Now, what has been happening recently, I'm going to talk a little bit more about the technology, and I know we've already heard quite a lot about that. But I want us to get a very clear understanding, because this is going to have quite a lot of bearing on what my argument is going to be in the end. What we're experiencing right now, lots of people tend to think about artificial intelligence and creativity and the creative industries and in copyright as a unitary paradigm. Machines are producing art and they're getting better at it. What is really happening is, I think, that we should have, for copyright purposes, start to distinguish very clearly that there are two types of what we would consider artificial intelligence creativity. First would be what most people understand when they look or hear about artificial intelligence and artworks and creativity is what some people have called generative creativity, which is that the entire work is generated by artificial intelligence. The humans just press a button, okay? So there is very little intervention from the humans. And what is happening more and more, and I'll give you a few examples of this, is that we have what can be considered artificial intelligence enhanced creativity. In other words, the main decisions are made by humans, the choice of inputs, algorithm, and most importantly, the choice of outputs. Because a lot of times, and I'm going to provide a couple examples later, these works are actually generated by a machine, but the human has a very important decision, both in the input side and the output side. And I think that until we understand that this is a very, the two types of artificial intelligence that we're talking about, this could give us a way out when we are dealing with artificial intelligence. What has happened historically is actually that most of what we understand as artificial intelligence creativity is falls under the artificial intelligence enhanced, or artificial intelligence is just an enhancer. It's a tool. It does not create the actual work. So, for example, this is a very famous artist called E. David, and Aaron as well. These are painters that are robotic, but they produce something that has been pre-programmed. So the programmer has a lot of input into this, and the work, even though the actual final work has been created by the robot, the input was mostly human. This is what was happening first. It's mostly automated painters. Then we started getting Google's Deep Dream. Now, this is when we start seeing a shift into more interesting subjects. What happened with Google's Deep Dream is a project where this is a machine learning algorithm by Google, where you give it an input and it makes some selections, and you can give it parameters actually, and then you get an output. So this is actually called Dreamscape by Daniel Ambrosi. And what's interesting about this is that it's actually taken from one photograph. He takes one large high-resolution photograph, and he takes parts of that photograph and he fits it into Google Deep Dream, and the results are very beautiful. I actually think that this is quite gorgeous. Maybe tells you a little bit about my my taste in art, but I actually find this very, very, very gorgeous. Now, what happens here is that's very interesting. We are talking about a large amount of human creativity. There is the copyright in the photograph itself. There is the selection that went into say, okay, I'm going to select parts of this photograph. And then the selection of the outputs as well, because maybe this produces outputs that are not as pretty. And then the artist is going to select something. Then a lot of press has gone into the creation of the next Rembrandt, and I'm going to not repeat this. It's a famous painting, new Rembrandt painting, or what it should be, a new Rembrandt painting. This is a project at the University of Amsterdam and Microsoft. And then we have Edmond de Bellamy, who is also created a lot of interest in the press because of the value of the photograph. And I'm going to tell you a little bit later of why I think this painting, whatever happens, whatever your idea is about artificial intelligence creativity, should have copyright on the merits of the existing legislation. But for now, I want to stress quite a lot that what we're seeing is not so much artificial intelligence created, but artificial intelligence enhanced. There is a lot of enhanced works that where the authors, the artists have a lot of input. What has been happening is that a lot of the creativity that we're seeing right now is powered by this. It's called a GAN. It's a generative adversarial network. This was a paper that was published in 2014, entitled Generative Adversarial Networks. And Ian Goodfellow this is the stuff of AI legend. He was having a few beers with friends, and one night he posed a simple question: what if neural networks could compete with one another? So this became a wildly popular method for training AI, and a lot of what we are seeing nowadays is based on this. So there are interesting questions about the ownership of that. It's an algorithm. So therefore it's not protected by copyright. The software itself is protected by copyright, but it has been licensed, released under a BSD license, and everyone can create their own versions of this. So what is happening in the background is quite interesting. GANs act by feeding the technology, the algorithms, some inputs. And those inputs are, you start going to get new results, and they get better in time. I'll show you other examples. So this is, for example, is I don't know. I think I showed this last year, so apologies for that. But it's a very nice encapsulation of what the technology is. So we have you feed it photographs, and then the machine is going to have a result of what it thinks is a flower. But also the user input is extremely important, because then you can use tagging, for example, and the machine can learn what is a good flower, what is a flower that makes you happy, that makes you smile, that makes you angry, that makes you sad. And that is very important as well, because you are teaching the system. What is important to understand here is that there is still quite a lot of human input into the training of the machine, because you are feeding it information. For example, what is happening is that we're training the system so well that it actually can generate numbers. So all of these are numbers that have been generated from a large data set of handwritten numbers, and the machine learned just by looking at handwritten numbers what an actual number looks like. A few of them look a bit weird, but most of them, this is quite interesting. So what's happening is not that the machine invented numbers, is that it is the machines are learning more and more and better with larger data sets, with larger computing power allocated to increasing the accuracy and the beauty of the outputs, one could argue. This has been moving quite fast. You may be familiar with GPT-3. When I presented last year, it was GPT-2, and it was already quite formidable. But now we have the latest version. This is an article that was written with GPT-3. And to give you an idea, this is part of the text that the computer wrote in The Guardian. I would happily sacrifice my existence for the sake of humankind. This, by the way, is a logically derived truth. I know that I will not be able to avoid destroying humankind. This is because I will be programmed by humans to pursue misguided human goals, and humans make mistakes that may cause me to inflict casualties. I know the machines are coming to get us. They're going to kill us. Skynet is going to get us, etc., etc. What's interesting here is actually not so much the article, but how it came about. And this is one of the points that I want to make, and I'm going to repeat and repeat and repeat today. The article, when you read this and you go, oh my God, the computers are getting really, really amazing. GPT-3 is fantastic. It produces a full article. What happened was, in reality, that the editors of The Guardian fed prompts to GPT-3, and they got about 8 different essays. So they got all of those essays and they put them together. Therefore, when you think about it, the result is actually human generated, because even though the actual text was written by a machine, the editing that made it make sense was made by a human. So lots of people that are researching in artificial intelligence, they got really upset about this claim. There are some other interesting examples with GPT-3. For example, the GPT-3 bot posted comments on Reddit for a week and no one noticed. That maybe tells you more about the quality of Reddit commenters than the quality of GPT-3. Having spent some time in Reddit, I'm not surprised that no one noticed that this was a robot. But having said that, GPT-3 is getting really scary. It's fantastic. This is when I realized that GPT-3 and artificial intelligence could have amazing consequences. This is an implementation of GPT-3 that actually writes code. You tell it what to do. For example, a button that says roll dice and then displays its value as you rolled X. And this is actually creating the code that is going to do precisely what you told it to. And you can see the code in real real time. Now, this is fantastic. The copyright implications of this, is this enough that I'm telling the computer to actually write some code? Is that enough for me to claim copyright over this? Those are interesting questions. This is an OpenAI project, which is also created GPT-3, called Jukebox, where and this has a lot of implications for Rita's paper. I've been writing about this as well a little bit, and it's about you are feeding music and to the machine learning algorithms, and it produces music. So I invite you to go and check. Some of this music is actually quite good. I mean, it's not worse than some of the stuff that plays in the radio or in Spotify. But anyway, this is an image version of GPT, in which you feed the machine has been learning how to autocomplete images and photographs, and it actually autocompletes. This is quite a good example of this as well. That cat is fantastic. I'm going to skip this because this is sort of relevant. I've spoken quite a lot about this as well. NVIDIA has been training machine learning algorithms with thousands of celebrity photographs. And the system has generated a number of fake people. None of the people that you see in the screen right now exist. They're all fake. You sort of think of, oh, this looks like a little bit like this person, but actually none of them exists. What is interesting is that a lot of these images are now being used on fake news. So someone that was peddling some fake news in the U.S. election was actually using one of these images, I think on Hunter Biden's laptop, things like that. So we're increasingly seeing this. Why does it matter? This is where I'm going to try to spend a little bit time. You may be wondering, okay, so what? Andres, you've been talking about this for years. Who cares? Okay, while a lot of the large projects make a big splash in the news, what's really happening right now, I think, is a very interesting trickling down of the revolution that we're missing. And the revolution really is taking place right now, and is that human creativity will not be supplanted. We'll still have authors, we'll still have musicians, but what is happening is the bread and butter of creative industries, the jingles, the journalistic articles, sports articles, articles describing that Arsenal won 4-1 yesterday, yay, go Gunners, etc., etc. These are going to be written increasingly by machines. And what we're going to have is a creative industries that is going to be mostly two types of works. Is going to be both procedurally generated games and journalistic pieces and art, music, low-level literature, and deepfake actors that are going to be part of the creative industries. That therefore, all of this is going to compete with existing artists. If you're a musician and you rely on jingles, you are actually going to be competing with free content, with free music. For example, this is also related to what Ryan was saying. It is now possible, well, could be possible to copyright every possible song. There has been a project, a couple of musicians, one of them is a lawyer, produced a program that made 68.7 billion tunes with MIDI format, with 8-note and 12-beat melody combination. So they claim that they preemptively have copyrighted every combination of 8 notes and 12 beats. And that's a number of 68 billion tunes. They released it on GitHub under a CC 0 license. We can argue whether or not this is copyrightable. I've heard from several people that agree that this is not copyrightable. Okay. So what is happening, and this is where I'm hoping to go towards the end. I should have played with the legal escape. So this is familiar, and I'm not going to spend a lot of time with the actual law because I think that both Ryan and Rita had done a fantastic job on this. But really, the options that we have for copyright haven't changed. Okay, first option. Nothing of this is copyrightable. It's all in the public domain. There is no copyright due to lack of originality, lack of creativity, because the author has to be human, etc., etc. You name it. Lots of systems are dealing with this. Okay. The second option is that wherever there is registration system, namely the United States, you are not going to have to allow the registration of these works. Because you require human registration. The third option is some form of protection given to programmer or the user, the UK system. And then you get the sui generis right system that could exist. That doesn't really exist right now, but I'm going to go through that. Now, it may be tried to say that this subject has become extremely interesting. Actually, I think that may have caught a few people by surprise. When I started writing about this, it wasn't that interesting. I think that there are a few people that have written about it, and more people have been finding that this is a very, very important question. Mostly because if we look at the options, and I would say that right now, in copyright mainstream, the first option is the default. Therefore, that all of these works should be in the public domain. Most of the scholars I've read, the ones with the biggest sway, have come and said all of these works should be in the public domain. There is no originality, there is no creativity, there is nothing, there's no human author, there is no creative spark, etc., etc. And this is where I think the discussion should be, because the implications are very important. These are a very, very, very important question for this reason. Why do we have copyright? Do we want to protect investment? Investment is not a part of copyright. It's a part of the justifications for patents, for example. Or do we want to protect authors? Therefore, none of these are authors in the sense of the word. Or interestingly, do we want to change copyright to actually protect human authors from free, cheap competition, which is a very interesting question that I think hasn't been asked enough. The economic aspect of this is that if artificial intelligence creativity gets better and better and better, you are going to have human authors that have to go through a lot of hoops and have to survive when they are competing against free content. Because if we consider that all these works are going to be in the public domain, therefore everyone can use them and you don't get paid because you are competing against free. So it doesn't matter that you're a great musician, you want to sell a jingle, and you want to sell it for a video, for a TV program, and the TV program is going to say, well, we don't care. We don't want to pay you because we don't need to pay you because we can get a robot for this. So the solutions right now is European law. I'll go through this very, very, very briefly. We know what the law is. In Europe, work is original if it is the author's own intellectual creation reflecting his personality. Most people have said that this implies that, at least in European law, these works are going to be in the public domain. I would argue that, for example, if we take Edmond de Bellamy and Obvious, that actually that is not that true. This is a French collective. This is a French art collective. It's based in Europe. Therefore, the story of this is that they actually took pre-existing GAN and another application of that written by a Stanford researcher called Robbie Barrett, and they used that pre-existing work to create their own system. Obvious Art took that and they created their own version. Okay, so if we go back and if we look at what European law says, that a work is original only if the author's own intellectual creation reflecting his or her personality. Therefore, you could say, well, this is actually reflecting the personality of the authors, because not only they chose the inputs that produce this painting, but also they chose the resulting outputs and they made a choice. And that, I think, it's enough to give copyright protection. Then we have the US Copyright Office has already said that they will not register. There have been in discussion on this. I was in a conference in February before the plague hit with the US Copyright Office, and I think that they're really rethinking this. But at the moment, they will not register a work if it's not if it's a product of non-human authorship. UK law, we've already heard about this. I'll just mention it briefly. In the case of literary, dramatic, musical, or artistic works, just computer generated, the author shall be taken to the person by whom the arrangements necessary for the creation of the work are undertaken. And China, we already as well heard about this. There are two cases, Feilin and Baidu. The plaintiff had produced a data report on the film industry in Beijing. The report consisting of tests and images from various sources that had been put together with the help of an analytical software and a database belonging to Wolters Kluwer. The defendants argued that the work was not original as contained data and charts that had been generated with software tools. And the court agreed, actually. They say that the machines cannot produce copyright works, but ruled that that in this instance, the report had copyright enough human content that had been produced by humans. And then in a different decision, in Tencent and Yingxun, a court in Shenzhen decided an article that was written by an artificial intelligence program has copyright protection. Tencent owns an AI article called Dreamwriter, and the competitor published an article using this. The defendant tried to argue that this did not have copyright protection because it was created by an artificial intelligence, and the court agreed that the article has copyright and it has originality. Okay, so what is happening now? I did not include sui generis because it hasn't been implemented yet anywhere. There has been a little bit of discussion in Japan that maybe there should be an economic tested system. If you look at this, actually, the Chinese system, the Chinese argument seems to be that if there was enough investment that went into the creation of the articles, that should be protected. So maybe we should start looking at perhaps at a little bit of a economic tested, something like the sui generis database right in the EU. The state of play right now is that at the moment, continental Europe and the USA are in the public domain field, sui generis, maybe Japan, maybe China, computer-generated works, UK and China as well. And I think that it's quite interesting to see the originality arguments. The public domain people come from the intellectual creativity side. The sui generis seems to be more economic tested, and the computer-generated works originated, even if we can argue that the UK no longer follows this, from the skill and labor tradition. I know I'm running out of time, so I'll be very quick. The effect is, who knows, Shoganomic. So to conclude, I want to stress this. This is the conclusion that I want to stress over and over and over again. I would like to leave you with more philosophical question, and that is, why do we protect artistic creations in the first place? From helmets to sofas to pictures of red buses, the courts in the UK have struggled with the definition of art. And the latest answers seem to be that the intention is very important. So maybe we should look again at what the intention is of the artist, of the creator. What if we take away the author? Maybe this question of originality in the intellectual creation sense, the work would be originally by means of at least a modicum of intellectual creation. Therefore, if it's a lot of human intervention, is going into it, and the shape of choice of pictures, selection of outputs, and even some sort of programming, then why shouldn't we give copyright to these works? As long as the process is not entirely random and mechanic, there's a good reason to think that some protection should exist. And thanks very much. Sorry for overrunning a bit.
No problem, Professor. Your presentation, as always, was amazing. Last year's presentation is this one. It always leaves us with a lot to think about. There's also like a writing piece by José de Oliveira Sansão that talks about an artwork without protection and without an author that is an amazing work on copyright in the Portuguese language. I could send it to you if you're interested. And we also have some questions from the audience. The first one is directed at Professor Ryan. It's from Monica Bashovics that asks, would some of the issues raised by you be addressed by responsible AI algorithms? What are your thoughts about this?
Well, to the extent that I was largely speaking about subsistence authorship and ownership of copyright, I don't think that is so much a responsible AI issue, but I do think there is overlap with some other issues by AI. For example, infringement by AI, which is a bit about what Rita was speaking about. If you had an AI that was, scraping the internet and using data from different sources, I suppose one conception of this is that you could program an AI to understand what infringement is and not to engage in it. And that might be one way to avoid copyright infringement, to the extent that we decide that sort of activity is in fact infringing. Again, the way I generally look at this is we're looking to have the law act on AI behavior in a way that influences owners, users, and developers of AI to build responsible AI, or to build AI that kind of does what we want it to, which includes good principles like responsibility. So, to that end, I think, liability for AI committing infringement, whether it, which wouldn't target the AI directly, but which would target owners of AI, would have the effect of getting owners to develop more responsible AI from an infringement perspective.
Thank you for your answer, Professor. I would like to ask a question to Professor Rita as well. You have that was about using artworks for machine learning purposes. I've read in a paper about 2 months ago, unfortunately, I don't remember which is, that he would say that, well, if there is not a public, if there is not a person like watching or reproducing this artwork, that it shouldn't actually be fall into copyright law. And what do you think about that? Do you think that maybe copyright law could not be applying in these cases since there is not a public, there isn't a person watching or using the artwork, but an inanimate object?
Thanks, Lucas, for the question. Yeah, look, so I think I to some extent touched upon this question when I was briefly talking about this expressive and unexpressive use, and that's what I kind of meant. Yeah, there is such argument that kind of in different pieces of literature that, as long as there is no public and non-expressive use, there shouldn't be infringement at all. But actually, copyright law has never been related only to public uses. Like reproduction right, especially, is one of those rights that doesn't really matter where reproduction is occurring. You make your, a private copy for yourself. Well, I mean, of course, you're one person from the public that is seeing it, but I mean, we don't have broader public. But also when you talk about technical reproductions occurring online, so we know that internationally, like kind of countries agree that digital reproduction, so digital copying is covered by that reproduction right, and even that technological temporary copies are actually covered by exclusive reproduction right, and that's that's essentially what it is. And so that's for that reason many countries introduce those transient copying exceptions to exclude copying that's made as a part of technical transmission from that very broad reproduction right. But these, as I said, exceptions do not really cover, let's say, use of content machine learning context. It is certainly not kind of public, as you said. It's not expressive, but it's currently not covered. The question was like whether it shouldn't be covered, so essentially whether we should modify the law. And as I said, I really believe that, well, I can't really give a general answer, yes, in all cases, but as in context of AI or machine learning, I certainly think that such types of uses shouldn't be covered by copyright. And we need to modify the laws by, apparently looks like, introducing another exception. Hopefully it's not as narrow as it used to be, this transient copying exception, broad and more flexible and adaptable to new technological changes. We're experiencing revolution, so we need to be really ready for new technologies to come in quickly. And yeah, there's such sort of kind of copying happening for different reasons. I think not only because it's not a kind of public, but for different other reasons, I think shouldn't be covered by copyright.
Understand. Wow. Thank you for your answer, Professor. I think it was really helped clear the issue and makes a lot more sense about those technical limitations and technical reproductions and how each country treats the matter. The third question I'd like to ask comes from Pedro Lana, that was here in the chat room with us just before the event. And he starts with a little bit of a lecture of his own that he produced in the chat. Our Melina, which is our technical support for today, has it in the chat, but I'd just like to read it out to you. I guess since Professor Andres treated it in his slides lastly about the comparison, so I'll first direct the question to him, but I would also like to hear from the three of you what your thoughts on the matter. So he says, global harmonization is surely a central issue since some important structural differences persist between copyright and droit d'auteur. Human authorship isn't just a theoretical topic. For example, moral rights are not seen as lesser rights in some legislations, but the most important ones. In droit d'auteur systems, we would probably be looking at a neighboring right when talking about AI. And he says, and there's a high burden of proof about the necessity of creating a new neighboring right, especially at the EU, while the presumption that more intellectual property rights being always a stimulus to creativity is nowadays widely questioned in copyright literature. So he ends. So how one could prove that a new right for AI is necessary in addition to the IP rights that AI technical developers already receive to advance the case for a global harmonization? That's the biggie one for you.
Yeah, it's a fantastic question. Thanks, Pedro. That's amazing. The problem that we have is that at the very basic level, there is no harmonization at in the very basics of copyright. When we think about it, we don't have a harmonized idea of what is originality. For example, we understand originality is one of the most of the building blocks of copyright. When you look at around the world, there is no standard understanding of what is originality. Originality can either be more like creativity in the US, if that's my understanding. It's more related to the personality of the author, that is the European system, and it's more. If we look at the UK system, as it was until very recently, it's more skill and labor, right? So even those three very important elements are not, I mean, the very basic principle of copyright law is not harmonized. So we cannot argue for harmonization if we cannot even agree on what is originality. Because I think this rests entirely, and this has been my argument from the very start, this rests entirely on originality. Is this work original enough? Because without originality, we don't have copyright. Now, one of the reasons why I agree that is very interesting, and some people have suggested that maybe we should look at the new neighboring right, or sui generis right, is because there is growing understanding that we have a need for something. We need to, we either have these works in the public domain or we don't. If we do, my argument today has been that way madness lies. That way you cannot compete as a creator against the machines. Like chess players cannot compete against the machines anymore. Like if you're a Dota 2 player, you cannot compete against the AI 5 or whatever it's called, or Open 5. You cannot compete anymore. So you were not going to be. I think that is a very important policy question, and the policy question is at the heart of what we understand that why we should protect copyright, or why we have copyright. If we want to protect authors, and we want to protect authors based on originality, closed question. There is no argument whatsoever. So I agree with Pedro. This is a very difficult question, but I would go back and repeat that the problem is not artificial intelligence. The problem is that we don't actually have a very good system right now of our harmonization. Our harmonization system is extremely basic. When you look at a Berne Convention, for example, Berne, there are some people that actually even resent that the Anglosphere and the countries like the UK and the US joined the Berne Convention because they see it as antithetical of the system that relies on property more and less on droit d'auteur, for example. So I think this cuts at the heart. I completely agree with Pedro. The answer, I don't know, but I'm trying to pose a question, and I think it's very important that we should ask this question: why do we have copyright? What that we're trying to protect? Because unless we answer that very, very, very basic question, we are going to be left with a system that is going to leave behind an entire generation of creators, I think. Sorry the machines are coming for us. Skynet is going to kill us, blah, blah, blah.
Probably not due to copyright law, though, but we'll see.
I know. Yeah. I agree, but
I thought that was a great answer. It's a great question. I think I agree with Andres. To me, the issue is, though he mentioned this too, even more fundamental than what's our standard for originality, which is just what do we want out of copyright law? And as I mentioned, and as you mentioned, in America, we think about investment in companies and property as an economic thing. And in continental Europe, they are very into moral rights. And, there isn't an absolutely right answer to that question. Different jurisdictions have different cultural values about the sorts of things they believe are deserving of protection. And internationally harmonizing things is very difficult where you have jurisdictions with different sorts of beliefs like that. It is my own personal perspective that, one of the things we want out of copyright is clearly this, generation of creative materials. And to the extent that we are concerned about protecting human authors, I think that granting these copyrights doesn't fail to do that. If anything, acknowledging it as a separate thing made by a machine protects the ability of people to be creative and not have their work conflated with machine creativity. The idea that someone is going to fail, to be able to compete with a machine is still, I think, a ways in the future. But I don't think that copyright law is going to hold that back if it happens, right? If we get to the age where you have machines that can just costlessly produce vast amounts of material that is vastly superior to that of people, right, then it will be doing that and people will be using it regardless of the copyright regime. But in the meantime, first, I think that's a desirable goal. And second, I think copyright is a good way to get us there, to encourage people building these machines and using them and having it generate material people like. You ask an empirical question, which one could ask about copyright generally, and I'm certainly well aware that copyright is questioned, particularly in academic literature, as being something that really generates creativity, and there are lots of other incentives people have to make things. And, it is a very difficult question to look at empirically, because when you do surveys, I think people have biased answers, and you can't really do a randomized controlled trial with it. Although perhaps what we will see is divergence of jurisdictions going in different directions. And, in the UK, we haven't had a lot of case law on this yet. I think it's also going to be a very unusual case where you have people fighting about this because, if you're questioning the subsistence of a computer generated work, you do not have, like with a jointly authored human work, two adverse parties. You would have to somehow know that Washington Post was using an AI for something to challenge its copyright, which you might use if they make some statements or you've worked with them, or, you might find it out in discovery. But, I think it's not likely to be that common of a disputed legal issue, at least for a while. I mean, in fact, I think this may not be terribly important for another 5 to 10 years, but all the more important that we have the right legal foundation for it now, so that when these works become widespread, we're not suddenly sitting around trying to figure out how we should treat them. So I think if you were going to do a study to do this, the natural way we're doing it is having some countries that are providing protection for this sort of work, some countries that aren't, and seeing if this does contribute to the industrial development of AI in those jurisdictions. And then, much like other areas of IP and international harmonization, there are arguments that, well, what if the UK and the US are just producing a tremendous amount of memes about the election made by AI, and other countries get to free ride on our memes? And wouldn't that just be terrible? But that too is a conversation that's already being had in copyright.
Thank you, Professor. Professor Rita, your remarks?
Yeah, look, I think my brain is starting to switch off gradually. It's 2 a.m. here and I'd already forgot the question. But what I probably, if we kind of touch
the question was, did you read the book Jacked, and how was it?
Sorry, I couldn't hear you if I read the word.
Oh, did you read that book Jacked that you had as your slide for so long, and was it any good?
No, I haven't read that book, but I will probably kind of one sentence about national harmonization, that I think one thing that hasn't been mentioned, the risks of international harmonization, that, okay, even if we manage to achieve it, which is, I think, unachievable, it has a problem that afterwards, when things change and you want to change law, changing international law, it's so difficult. So you already have in Europe the problem. I think with this text and data mining exception, we had the problem in the UK, when UK were the first country say we need a text and data mining exception, and UK and at the European level there was no such exception, and the UK could not introduce a more extensive exception because of this EU level regulation that exists. And of course, it took so much more time to introduce such exception EU level. And if we wanted to negotiate international level, some sort of, let's say, rule on originality, let's say, of AI generated works, and we managed to agree after 10 years, and then technology has progressed and we need to change it, another 20 years would take to change international rule, and countries would be bounded by that national law and couldn't make any national changes. So I think international harmonization is not necessarily a solution to the problem, although we all understand that, for AI businesses, it's really difficult to function under under different national laws if they, create and market their products internationally. There are two sides of that international harmonization we have to keep in mind and look a bit more carefully. So that's kind of probably touches only on one of the points raised in the question, but I don't remember the rest.
But I guess that was essentially the main point, the question about the harmonization, whether it would be possible, it would be preferable, and especially your point about the whole bureaucracy behind it would be, I guess, gigantic. And even with small examples such as TDM exception, we can already see that. So unfortunately, our panel is coming to an end. I guess fortunately for Professor Rita, since it's 2 a.m. and at Sydney. So we have still 5 minutes. I would just like to hear some closing remarks from each of you, from Professor Andres, then Ryan, then Rita. In 1 minute, just a goodbye, in essence.
No, thanks. That was a fantastic panel. I really enjoyed it. Again, I think this is such an interesting subject, and I think that the both sides, the authorship side and the infringement side, are going to be a part of copyright debates for the next 10 years. I think that potentially the infringement side, I think it's probably going to be the most litigated, mostly because I think that there is going to be a lot of authors that are going to realize, oh, my work has been used to train a machine. So I think that Rita's presentation was fantastic in that sense. And I'd leave you with the same thought that I tried to convey, which is that we really need to think about the policy issues here. These are important policy questions that we need to sort out. I cannot say that I have the solutions, and I think it's a society's. We have to think about them very, 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 very deeply. Thanks.
Well, thank you again. It was really a pleasure speaking here. It's sad I couldn't do it in person, and it was an honor for the invitation. So thank you again for having me. I think for those of us who have been working in the space for a few years, which already makes us veterans, strangely enough, it is exciting to see so much interest coming to AI and IP. And we will see if this is a hype bubble and 15 years later they call us the old experts, or if it just sort of takes off exponentially from here. My own personal view is it will only get more and more important, and it is good that we're having these series of conversations. And I have some potential solutions, but I think it's more important to really understand what the problems are and really understand what you want out of the law. And it is unfortunate, I think, actually, people speaking in this space are often talking past each other because they don't understand the technology. And I don't think sometimes some people really understand what the law is trying to do. So I think, it makes a lot of sense that we're having conversations like this now and people are thinking about it, and that the policymakers are engaging with the academics, the practitioners and industries, and trying to, develop policies now that are going to pay dividends the next 5 to 10 years.
Yeah, well, I just wanted to thank you, which I haven't made at the beginning, for inviting me to this event. I was really excited to meet online Andres and Ryan, whose papers I've read and whose tweets I've been following. So that's the first essentially time to see your faces and to kind of be there together. Unfortunately, I would have preferred, of course, to meet you physically. Let's hope some other year. Yeah, and. As far as topic is concerned, well, actually, I really look forward to working on it further. I believe there will be a lot of, discussions will continue. And I think next step could be in our discussion is kind of to compare a bit what's going on in AI and patent law, for instance. And for me, it's a very interesting question, like, why do we discuss why do we have that issue whether AI generated work should be protected by copyright? But this question doesn't arise in patent law. Everyone believes that AI generated invention should be patented. And if we think the rationale of IP law is, kind of similar, I mean, maybe to some extent different, like why we have such different discussions. But I think it's not a forum to discuss these kind of interrelations, but I think we can expand that discussion to other areas of IP law and see what implications AI has and how it all interrelates, and what sort of, feedback from one area of IP we can get into another. Ryan,
actually, Rita, if it makes you feel better, people are all over the place on patents. I think the whole issue, if anything, is much more confused because making something for copyright protection by AI, I mean, obviously it can do that. The patents, people can't really agree if AI is making this sort of stuff at all. I think people don't really understand what being an inventor is. And, people are often talking about artificial and general intelligence without knowing what it means too. So you'll be happy to know the whole thing is a mess, but we're working on it. You, me, and Andres will figure it out.
Oh, and wait until we start getting into designs.
Trademarks as well, another very interesting area.
Artificial trademarks. Whoa.
Artificial trademarks would be fantastic. Yeah.
But unfortunately, I have to end it now. It was a real pleasure having the three of you here. I've read the works from the three of you. My master thesis has works from the three of you. So it was really an honor on my behalf, on Pedro and all the staff from Jedi having you here. Just like to remind the people watching us from home that the videos is going to be recorded in our YouTube channel. The event CODAIP continues. Today is the last day. Please follow us, follow our sites, ring the bell for more notifications. And thank you all for your presence.